Joining me today is Dr. Michael Arnheim. Dr. Michael Arnheim is a barrister in London, which, if I understand correctly, is sort of an elite lawyer position within the judicial system in the UK. He's also an American law and U.S. constitutional scholar. Dr. Michael is also the author of 22 books, including titles such as Principles of Common Law, Anglo-American Law, A Comparison, Practical Guide to Your Human Rights and Civil Liberties, and the book that we'll be talking about today, U.S. Constitution for Dummies. Thanks for joining me today, Dr. Arnheim.
Sure, thank you. And of course, this is the second edition.
Yes, this is the second edition. I read the first edition originally. Can you even see that? It looks like it's upside down. Okay, there you go. So I read the first edition, and that was about a month or so ago. And then I discovered, you actually brought it to my attention, that you have a second edition I wasn't aware of. I just finished reading that like 3 hours ago. Okay. So unbelievable tool, unbelievable resource. As far as trying to get yourself familiar with the U.S. Constitution, it's a fantastic way to dive into the topic. It's so good at not only providing the basic components of the Constitution, but also explaining the story, the arguments, and the confusion surrounding parts of the Constitution. It's also easy to read, and it's funny. You crack a lot of jokes in the book, which is cool. So big fan, big fan. I tend to love the Dummies books in general, though. I've read the Personal Finance for Dummies book. I'm also reading the Insurance for Dummies book right now. The Dummies books really seem to speak to me. I'm not sure why, but all of the Dummies books I've read, this is my favorite by far. So
well, thank you very much for that.
Thank you for joining me. So originally I was going to start off with a series of questions with the purpose of laying out some background on what led up to the Constitution, what influences did the founders and framers draw on, such as the Magna Carta and English common law, what was wrong with the arrangement that predated the Constitution, namely the Articles of Confederation, and in what ways does the U.S. Constitution, in what ways is it similar to the Constitution of Great Britain, and what ways is it different? But then I wrote the rest of this interview, and I realized I was trying to cram 4 hours of questions into a 1 hour show. So for the sake of time, I'd like to offer you a chance to quickly lay out the foundation and backstory of the U.S. Constitution as you fit, and even if you want to compare it to your system over there, that would be cool, as long as it's within 5 minutes or less. Okay?
Sure. Well, thank you for that, John. I really appreciate it. And hello, everybody. Thank you for tuning in. It's a tall order, but basically it's about how 13 colonies decided to break away from the mother country and managed to make a go of it. With one or two ups and downs. The Constitution, the British Constitution, is still unwritten. So the idea of writing it down is really a fairly new idea, which came from America, although there was also a Polish one similar to that. Well, it's not similar, but the idea of writing it down. And actually, there was a written British Constitution in the 17th century during the Cromwellian period. Well, that didn't last. But there are similarities, of course, because the American Constitution is more or less modeled on the British Constitution, which is what the American colonists were familiar with. But it also made a deliberate effort to differ from the British Constitution in many respects. Well, they didn't want a king. So that got chopped out. Originally, there was no executive at all in the original Constitution, but the Confederation, not to be confused with the later Confederacy, but then they realized that they needed a strong executive, and that became the president. But one thing they didn't seem to understand is that there was a distinction between being head of state and head of government, which even in Britain was not understood at that time and has developed only by accident, like most things in Britain happened by accident, where now the Queen is the head of state, but she's not the head of government. There's a prime minister who's the head of government. In America, the president is the head of government and the head of state. Actually, I think that is a pity in a way, because having a separate head of state has turned out to be quite a good idea of someone who is above politics. And it's been copied in many countries throughout the world, not just monarchies, but also republics, like Germany, or Switzerland, obviously, Finland, many countries where the president is very, very much, I wouldn't say only a figurehead, but essentially is above politics. One of the problems that's emerged in that regard in America is with this kneeling at football games and so on, taking the knee, because people are attacking the country by doing that. They're doing that during the national anthem, which is attacking the country, when in actual fact they're not attacking the country, they're not attacking the head of state, they're attacking the government. They want to attack the government, but because the two are rolled together in America, they have to do it in that way, and that looks as though they're actually unpatriotic. So I think it would have been good if the president had been just the head of government, or if someone else had been the head of state and the president had been head of government, or vice versa. And there are many other differences as well. I won't go into it all, but in particular, in Britain, you can never have a situation where the executive and the legislature are against each other or are run by different parties, because the executive emerges out of the legislature. Parliament, there's a parliamentary election. There's no separate election for the executive. There's a parliamentary election, and whichever party has a majority in Parliament becomes the government. And the government really controls the legislature.
Okay.
That may or may not be a good thing. All right, well, I mean, I'm going through, I'm taking much longer than I should.
No, that's fine. Please continue.
Magna Carta, you mentioned. That's, yes, it's a name to conjure with, more so in America, actually, than in Britain. And it's got to be remembered that this dates back to 1215, the year 1215, when I was still fairly newly called to the bar. So it's quite some time ago. And King John was forced to sign that by the barons. The concessions he made are not to the ordinary people, but to the barons. That has been, of course, that has been widened since then. But it's sometimes suggested that the idea of a jury trial, the idea of habeas corpus, the idea of no taxation without representation, all come from Magna Carta. Well, only in the vaguest possible way. Only in the vaguest possible way. There is only very few clauses of Magna Carta survive in the law in Britain today. The idea of trial by your peers, I mean, that's eventually turned into jury trial. But actually, of course, unfortunately, in Britain today, jury trials are practically non-existent now, except in cases of serious crime. Oh. So in some respects, the American Constitution is closer to the old British Constitution, and I think jury trial is one of the really good things about it.
Okay. And so the Magna Carta is probably more revered and more romanticized by us than by you guys.
It is, and that's why the Magna Carta monument, which was put up in 1957, was actually paid for by the American Bar Association, although it's in Runnymede in England, where King John signed the agreement. Why do you need a book on the Constitution, or do you need an explanation?
Yeah, so that was actually my next question. I was going to ask you in chapter 1, you write the whole text of the Constitution takes up just a few pages of print. And you go on to ask, so why do you need a book this long in order to understand it? So that's a great question. Let's start there. So why do we need to read a book this long to understand it?
Yeah, and it is quite a long book. And it's actually got some very nice pictures in it as well, I have to add.
Yes, it does.
Actually, you do better reading it in Kindle, as far as the pictures are concerned, than the print version.
Okay.
Because the print version only has the pictures in black and white, whereas Kindle has it in glorious Technicolor.
Oh,
so
nice.
And of course, the Kindle is a lot cheaper. But just a little plug there. Well, 3 things, as I put in the book. First of all, old-fashioned language. Secondly, ambiguity. And thirdly, the need to interpret, because in such a brief document, it's not always as clear as it might be. I think one of the best examples of all I can give is, that's of ambiguity, is the provision about the vice president taking over from the president when the president is disabled or has died in office or has been removed. And that, the first time that came into play was when William Henry Harrison, elected in 1840, and then inaugurated in those days on the 4th of March, 1841, and decided to give a very long speech. I think it's still the longest inaugural address, without wearing proper winter winter overcoat and anything. And he was the oldest president up to that time. He was 60 years old, and he caught a chill and died within a month. I mean, whether he really died from his inauguration, I don't know, but he was there for 1 month before he died, and the vice president, John Tyler, took over. Now, Harrison was a Whig, and the Whigs were not too bothered about political ideas or programs. They just wanted to win. And so they got Tyler, who was really a Democrat, a Southern Democrat, as the running mate, not thinking that he would ever become president. But anyhow, he took over from Harrison, and the question was he acting president? Everyone knew he was standing in for the president now, but was he the acting president? Was he maybe still vice president in a temporary capacity as president, or was he the actual president? And the Constitution was not clear, but he made it absolutely clear that any letter addressed to him as acting president or vice president, he would tear up immediately, and he had to be recognized as president. He managed to get that through Congress, although he disagreed with Congress on practically everything else, and he was at total loggerheads with Harrison's cabinet, which were all Whigs, and he was not a Whig. So that actually changed the Constitution by virtue of the practicalities. But the actual Constitution, the wording didn't change until 1967, when it was provided finally that yes, the president, the vice president does become the president, not just acting president.
And after reading your book twice, there's just so many examples of things that seem to be left out, or things that are vague.
Well,
It's
yes,
really surprising.
well, what is more surprising actually is the way the founders or the drafters, they're not exactly the same people, managed to think of so many things that were important. They couldn't think of everything, but it is a brilliant document, actually. It's a brilliant document.
Sure. Now, the vice president that became president that you just mentioned, is that the one that they jokingly called his accidency?
Yeah, exactly. He was called your
accidency.
his accident,
Instead
president by accident.
Yeah.
And no one was really expecting that. The vice president, position of vice president has always been slightly anomalous, and in fact, I think it was Franklin Roosevelt's first vice president who described the vice presidency as being not worth a bucket of spit, as it's now. You see it reported now, it's a bucket of spit. Actually, it was a bucket of piss.
Oh. But that's until the president dies. Then it actually works out.
Of course.
Which is probably going to happen sometime soon with Biden and Harris. Not to get political, but.
Well, it could be. It could be. I usually refer to as Vice President Camel.
Yeah. So, you touched on something before briefly, but I want to revisit it and ask you, before the Constitution was a thing, our original document was the Declaration of Independence.
Yeah.
But was the Declaration of Independence the birth of one nation or 13 nations?
Well, I think if you read it, you'll see it is 13 nations at that stage.
Okay. So
it still wasn't one nation, because it still went through the stage of the Confederation, which also wasn't really one nation, but it was with the Constitution, the idea being a closer union, that it really became one nation. So now, although the term United States, plural, is used, it's always used as if it's a singular. The United States is a country in North America. You wouldn't say the United States are today. That would be completely wrong. So it's now definitely one nation, I think. But and of course the motto, e pluribus unum, from many one, and from more, literally one. And but initially, the Declaration of Independence is actually a Declaration of Independence of 13 individual states, and the wording there is all in the plural,
Now, when the Constitution was ratified, was it immediate that all of a sudden we are one nation, or was it more of a federalist system that kind of grew towards this more centralized control over time?
Well, yes. I mean, of course, the confederation means a looser union than federation. It was set up as a federation, which means that the states still had, and of course still do have, quite a considerable amount of autonomy. And there were certain special concessions made to the southern states to bring them in, because they were less populous. They had smaller populations than the northern industrial states, but what they had were slaves in the south. So the slaves did not have the vote, of course, but there was a 3/5 rule, which actually is still in place today in the representation of the states in Congress, in the House of Representatives, that every southern state, the population of the southern state would be based on the population of the white population plus 3/5 of the slave population, even though the slaves didn't have a vote. And that was what brought the southern states in. Otherwise, they wouldn't have joined. The 3/5 rule.
And that was, as far as I understand, that was a compromise, wasn't it? Because they would have preferred that the slave population be counted 1 for 1, but that makes no sense because they can't vote. Yeah.
Well, of course, no, the alternatives were not to count them at all, because they didn't have the right to vote, or to count them as individuals, which would make no sense because they didn't have the vote again, or to have some compromise, which this was, 3/5. So, and that was what cemented the Union, as it were. And all the early presidents, except for John Adams, came from the South, mostly from Virginia, and were slave owners. George Washington, I know, unfortunately, their statues are now being toppled all around the country because of that. Jefferson even had an affair with one of his slaves, and so on, and a lot of publicity about that lately. But John Adams was the only, because he came from Massachusetts, where slavery had been abolished, he was the only one of the early presidents who was not a slave owner, purely because of that reason, that he was from the North.
Okay. So when the Constitution was written, the preamble starts with "We the people," which sounds very democratic. But our founders and framers didn't really set up a democracy, though. They set up a republic, or a quote-unquote democratic republic. Now, in a real-world, nuts and bolts kind of way, what's the difference, and why did they prefer a republic as opposed to a democracy?
They were very afraid of the lower classes, that's why. The people we're talking about who set up the United States were all actually members of the elite. George Washington was the richest man in America, largely through his wife, who was the widow of an extremely wealthy man who'd left lots of slaves and everything, property to her, which became his. So they all were extremely well off, well educated, and they weren't inclined to share power with the hoi polloi, with ordinary people. And initially, the vote did not extend even to all white males. Now, you won't see that in the Constitution, because this is one of the areas left to the states. The states decided who had the vote. Some states, in fact, women even had the vote in the early days. In certain, they mostly had to be property owners, though. Not huge numbers of them, but that was the exception. But for the most part, it was property-owning males who had the right to vote initially, and this would have been about 10% of the white male population only initially.
So the "we the people" part, was that just like a sales tactic or a ploy to get people to embrace the Constitution?
Oh, yeah, I think so, and also similar to what it says in the Declaration of Independence about all men being born equal, and that was written, drafted by Thomas Jefferson, sitting on top of a menagerie of slaves.
Yeah.
No intention of giving slaves the right to vote. And although he is regarded as highly democratic by comparison, for example, with Adams, but it only really became democratic in any modern sense from the time of Andrew Jackson. And that's why we talk about Jacksonian democracy, because he extended the vote from his time on in the 1830s. The vote was extended to practically all white males. And then, of course, it took another 100 years until 1920 before women got the vote. And of course, blacks got the vote in 1865 from the as a result of the freeing of the slaves, emancipation, and the amendments to the Constitution. But although in practice blacks did not have the vote, because again, this was a state-controlled system. Voting is still today controlled by the states, and of course, for many years after the Civil War, after Reconstruction, as it's called, right up to the 20th century, you can say, blacks were often denied the vote by either being required to pass a literacy test, which usually was made very difficult. They had to usually read bits of the state constitution, which is written in highly legalistic language, or they had to pay a poll tax, and mostly, of course, they weren't very wealthy. They couldn't do that. So that was a way in which blacks were deprived of the vote. But even today, of course, voting is still state-controlled, and that's why there's been all this fuss in recent elections, including the 2020 election, and of course the 2000 election, where it was Florida. Florida had a particular form of voting with the hanging chair and all that, which didn't affect other states because they didn't have that system. Florida has given up that system now for very good reason, because that caused a lot of confusion. And in the end, that decision of who was to be president in the year 2000 went to the Supreme Court, which really has no role in this sort of thing at all, or shouldn't have.
Okay, so I'm going to jump ahead a little bit and do things a little bit out of order. But since you're on voting right now, I was going to ask you, is voting ID unconstitutional?
No, not at all. Again, as I say, this is a matter for the states to decide.
Okay.
And my own view is that voting ID, voter ID, should be obligatory.
Yeah.
How otherwise are you going to know who is actually entitled to vote?
Yeah.
It's partly a question of citizenship. There have even been accusations that some people who are not even citizens have been allowed to vote. But that aside, they may or may not qualify under residency rules. They may not be from that state. They may be from out of state. It may have been brought in to vote for a particular party when they don't even belong in that state. And certainly there have been cases where it's known that dead people have voted in Illinois, in Chicago. It was well known that whatever you voted when you were alive, when you died, you were always a Democrat. And John Kennedy probably was elected by the dead people of Chicago. To maybe in Texas as well. I think Lyndon Johnson once boasted that his granddaddy had voted for him. His granddaddy had been dead for many years.
That's funny. So the reason I ask is I know that that's not the way they normally frame the argument against voter ID. They're not usually saying it's unconstitutional. They just say that it's racist. But they're saying that it's kind of like the like you mentioned before, the voter tax, I think you called it, or fees, whatever it was, or the literacy tests and all that kind of, they're lumping it in that category and saying that it's specifically designed to prevent blacks and minorities from voting, which I think is a little crazy.
Yeah, well, I think it's a bit overblown. It may well be that poorer people have more difficulty getting proper ID. That's possible. But a lot of states have gone out of their way to make it very easy to get ID. You go to the DMV.
Sure.
Even if you don't have a driver's license, you go to the DMV, you get a photograph taken. It used to cost, I think, something like $10. I think in some state, in many states, I think that fee has been waived. So as long as you can get yourself to the DMV, they'll take a photograph for you. They'll give you a card, which is to all intents and purposes like a driver's license. Only it says round the edge, this is not a driver's license. And it's used for ID purposes.
Yeah. Did you see the video of one of these YouTube people? He did like a man on the street type video where he went into college campuses and he asked mostly white people, is voter ID racist? And pretty much everyone said yes. Then he went to he asked them, well, why is it racist? They said, well, they probably wouldn't be able to get the ID. They're not sure how to do it and that kind of thing. Then he went to Harlem and he asked all the black people that he found walking around the streets of Harlem, and all of them said, that's crazy. Of course it's not racist. I have an ID. I know where the DMV is. You know, it kind of reminds me of just this past week, Biden made a comment that black people are not able to get certain benefits because they don't know how to go on the internet. I don't know if you heard that. They don't know how to go on the internet and apply for it. You know, they're not internet savvy. And, you know, I know a lot of black people, and that was a surprise to them. They had no idea that they didn't know how to use the internet.
Well, it's true that poorer people will probably have less access to the internet, less knowledge of the rules and so on. But there's so much help available out there now,
sure,
especially that I don't think there's any excuse. And I think that the real point is that you've got to guard against people who are not entitled to vote voting. And that's a serious problem.
Sure. Which I believe there was probably a lot of that in 2020.
That's still going.
Yeah. And that's definitely something I want to discuss with you today a little bit.
Sure.
Okay. So let me move along. So when the Bill of Rights was originally written, was it meant to apply to the states, or was it simply referring to what the federal government can and cannot do?
Well, originally, the Bill of Rights applied essentially to the states, it seems. But as time has gone by, the idea it's been expanded so that now all the articles of the Bill of Rights.
And was that through the 14th Amendment?
The first eight amendments now apply to federal and to the states as well. Originally, it was originally meant for federal only, but the idea is now that it extends to the states. The first eight, anyway. But certainly, the whole Constitution is really only about federal government. So therefore, it was only the federal government that was obliged to follow what was said in the Bill of Rights. It was purely for the federal government because the whole Constitution is about the federal government. Each state has its own constitution, after all. So the amendments, the first eight of those 10 amendments have now been extended to cover the states as well as the federal government.
Okay, so the first eight
was only for the feds. It was only for the feds originally.
Okay, so it's the first eight. It's not all of the amendments. And
this has been done piecemeal over the years by the Supreme Court. There are a couple of exceptions still, like grand jury. That is still not applicable to all states unless the states want it. That doesn't apply automatically, and not all states have a grand jury. Also, jury trial in civil cases. Those are the two exceptions from the Fifth Amendment that still don't apply automatically to all states. But otherwise, all of the first eight amendments do apply to the states as well as to the federal government, which originally was all it was all intended for federal. The last two of the Bill of Rights do not apply to the states, and some people have rather dismissed those, the 9th and 10th Amendments, as being not very important. The 9th Amendment has been described as an ink blot. But unfortunately, Judge Robert Bork described it as an ink blot, but I think he was very wrong. Very wrong.
So you said that this happened over time, piecemeal, but did the 14th Amendment kind of solidify a lot of this as far as the Bill of Rights, or at least parts of it, applying to the states?
Yeah, the amendments made after the Civil War, 14th, 15th, 16th Amendment, those amendments were done primarily to bring the southern states into line, to bring them to book. They're really quite punitive, and they were designed, yes, to bring the southern states who had been defeated in the war between the states, as they say in the South, or the Civil War, to bring them into line. So yes, that certainly had something to do with it.
Okay.
The scope of the 14th Amendment, particularly, has been so greatly widened that I can't believe that it was intended at the time, even though the people who drafted those amendments were not in the same league as the original drafters. I call them the Little League, Little League drafters. They were very, very partisan and very angry men, and they didn't have the same educational background or general. They weren't of the same class on the whole as the original drafters, really.
Yeah.
So, 14th Amendment, the due process clause of the 14th Amendment has been so widened. Of course, there's a due process clause in the 5th Amendment as well, but it's not. It goes so far beyond what was intended. In fact, we've got things like abortion, privacy, abortion, gay rights, gay marriage, all that coming out of due process, really.
Kind of reminds me of the Commerce Clause.
Yeah, the Commerce Clause has also been interpreted in very many ways.
Yeah,
which has caused a lot of fuss. Not as much as the due process clause, I would say, but because it's more to do with economic things which affect a fewer people.
Yeah, but the problem is it's been used for things that have nothing to do with economics and interstate commerce. So it's you know,
it definitely has.
So, and I read in your book that the Supreme Court case of 1833, Barron versus Baltimore, the court declared the Bill of Rights binds only the federal government, not the states.
Yeah,
so
that's right.
So it definitely was only for the federal government up to a certain point. And I think this is I think this is one of the things that people struggle with the most in understanding the Constitution, is this kind of dynamic between the states and the federal government, and who controls what was the original intent, how does it work? You know, that's why.
As I said, the original Constitution is purely for the federal government.
Sure.
The federal government has no direct authority over the states, except within the framework of the federation.
Sure.
But the federal system of government. But each state has its own constitution. So that's why voting rights can differ from one state to another. They don't at the moment because, of course, there are amendments to the Constitution which have given everyone over the age of 18, for example, the vote. They gave the vote to women. That all was done by amendment to the federal constitution. But that meant that the states had to abide by it. But otherwise, the states still do have a fair degree of latitude in the way they run elections, as I was saying before. But yes, it's all intended, the original constitution was intended purely for the federal government.
Mm-hmm.
But up to 1833, which is just the end of the time when John Marshall was Chief Justice, that was the position. And then later, quite a lot later, things started to change. But that was really only after the Civil War, when they wanted to bring the southern states to heel. But
it is confusing for the average working guy like myself. I'm just a working guy. You know, I'm not a constitutional scholar. And that's why your book, U.S. Constitution for Dummies, really is so awesome to help get people up to speed on this kind of stuff. Because after I started reading this book, I can hear a lot of my Facebook friends talk about the Constitution, and I'm already starting to see where they're a little bit off in their information, you know. So it's definitely...
Well, unfortunately, the Constitution is a political document, so therefore people will interpret it in accordance with their political preferences. And for a long time now, the Constitution has been practically monopolized by the Supreme Court, the U.S. Supreme Court. That was the fault of John Marshall, who back in Marbury and Madison, the case Marbury versus Madison, 1803, more or less monopolized control over interpretation of the Constitution, which was never intended to be the case. Thomas Jefferson went wild over that. He was absolutely livid. He absolutely hated John Marshall, who was actually a distant cousin of his, and he was planning on having John Marshall impeached, but he never quite had the courage to do it. And John Marshall probably wouldn't have been. Everyone liked John Marshall, actually, except Thomas Jefferson, of course. Everyone thought John Marshall was such a charming man, such a mild-mannered person. He was, you know, delightful to talk to, very witty and all that. And I think his fellow justices in the Supreme Court all liked him. They used to share a rooming house together in Washington, D.C., because the court didn't actually meet that often during the year, and they went on circuit in those days, the judges, the justices. But when they were in Washington, they all shared one rooming house, and they got on very well together. And which was, if it's raining anywhere, you can drink as long as it's raining. You can drink as long as it's raining. And John Marshall would look out of the window and say, well, I'm sure it's raining somewhere, so we can drink.
That's funny. So yeah, that, you know, that what you were discussing right there about what's called judicial review, that's definitely something I want to get into today. I'm going to save it for a little bit further down the line. Right now, I want to get into a couple of the actual amendments, a few of the amendments, actually. We don't have time to discuss all of them, but let's go through a few of them if we can. I'm going to start with the First Amendment, and I'm going to read it here in your book, chapter 14, page 192. Here's what the First Amendment says. Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof. Now, so this is what is often referred to as the separation of church and state part, but did this mean what most people assume it means? Was there a separation of church and state at the state level?
No, not exactly. And that really has come about through a letter written by Jefferson much later. It's been interpreted in the light of that, which is not part of the Constitution at all. What that amendment really means is there is not going to be a national church as there was in England, and it still is. There is the Church of England, which is still the official state church, state religion of the country. And to this day, you cannot be king of England if you're not a communicating member of the Church of England.
Wow.
And until recently, even if you married someone who wasn't, you had to give up your right to the throne.
Wow.
That was recently changed. But so you can marry somebody who is not Church of England. But that is the established church. There's an established religion. Now, that's the one thing the American founding fathers or drafters wanted to get away from. No established church. No, that's basically what that is saying.
At the national level.
Yeah, of course, it's talking about Congress there, national level. So that's the idea, that not exactly separation of church and state. That was the interpretation put upon it by Thomas Jefferson. But no established religion, no established church.
Okay. But now, is it still the same way now that the First Amendment is incorporated, according to the Supreme Court?
Well, yes and no. I think it's now understood to mean that there should be a separation between church and state.
Okay. Even at the state level now.
Oh yes, yes.
Okay.
First Amendment is definitely incorporated.
All right.
The second part of that amendment is, of course, about freedom of speech, and that is very interesting. If you read the wording, read out the wording of that. I haven't got it in front of me here.
Yeah, definitely. It says here, or abridging the freedom of speech or of the press. Now, does this mean all speech, all forms of expression?
Yeah, well, the crucial word there is the, actually, the, and that's mostly ignored. Read it again.
Bridging the freedom of speech.
Yes. Why does it say the freedom of speech? What freedom of speech? In other words, that refers to an already existing freedom of speech. Abridging the freedom of speech. In other words, the freedom of speech that was already recognized in Great Britain at the time. That's what it's really talking about.
Oh.
It's not saying there shall be total freedom of speech. It's saying the freedom of speech that exists now, back in 1789, shall not be abridged. That's what it's really saying. People have missed that word. The word "the" is actually crucial.
Wow. That one little word makes a big difference.
Huge difference.
So it's not absolute. You can't, let's say pornography, child pornography, flag burning, any type of obscenities.
Except that the court has reinterpreted all these things. Flag burning, for example, which most people would think is nothing to do with speech, has been interpreted by the Supreme Court as meaning expression. As long as you're expressing your views, you are expressing your views by burning the flag rather than by speaking, so therefore it's okay. Frankly, I think that's a wrong decision. But that is the decision. Most conservative judges have disagreed with that, but not all. In fact, I should say the opposite. Some liberal justices have disagreed with that as well. But John Paul Stevens, for example, who was normally regarded, although he said he was a conservative, normally regarded as a liberal, totally disagreed with that, because he said that's unpatriotic. It's contrary to your loyalty to the country, flag burning. Nothing to do with freedom of speech.
So freedom of the press is also part of that section. So freedom of the press has been challenged many times and has not always come out on top, but for the most part has been more protected than not, I would say. You're right.
Oh,
And you write in the book about the Pentagon Papers, which were top secret documents that were leaked and published by the New York Times, showing the mishandling and failures of the Vietnam War. And the Supreme Court sided in favor of the New York Times for publishing that. Do you think they were right for siding with the New York Times?
oh, it's hard to say on that particular issue. Very, very controversial at the time. But I would say that there is some people sometimes assume that freedom of speech and freedom of the press are one and the same thing. And the press always like to give that impression that their freedom of journalists to write whatever they like, is covered by the freedom of speech. And if you deny them that freedom, you are denying that freedom to yourself as well and to other people. That's not true, I believe. The press has far greater power than ordinary people. And in fact, freedom of the press can actually be used to muzzle the ordinary person, because if you were to write an op-ed, this has happened, I think it was, what's his name, the Republican presidential nominee,
John McCain?
McCain, who wrote an op-ed for the New York Times, which they accepted initially, and then they regretted it because they decided that it didn't agree with their policy. But that is so wrong, because an op-ed, the whole idea of an op-ed is that it should give voice to people who don't always agree with your policy as a newspaper or as a publisher. And yet this was their approach. So usually you find that if a newspaper attacks a prominent person, that'll be on the front page, splashed on the front page. When they apologize to that person 3 months later or 10 years later, that'll be buried on page 33 in a very tiny article. So if at all, I mean, if they do that at all, if they even apologize, but which they very rarely do. But on the other hand, defamation law is much more liberal in America, in the sense that it allows more freedom of speech than in Britain. The British defamation law is so bad that it traditionally favored claimants. If you said someone defamed you, you would have a much better chance of winning. You didn't have to prove that what they said was not true. That was taken for granted. And in fact, that resulted in British defamation judgments not being recognized in America. And that is still the position today, even though British defamation law has changed to make it less plaintiff oriented. Even though that changed, there was a recent law, Defamation Act 2013, which changed that, supposedly, but it still has not satisfied Americans to the point where British defamation judgments are recognized. They're not recognized to this day. And I think that's right in a way, because freedom of speech should be encouraged, and the internet exists, which enables people to speak more freely. But what are the limits? Should there be limits? And of course, the second impeachment trial of President Trump relates to that, and there probably will be further repercussions about that. Was he actually entitled under the First Amendment to make that speech, which resulted in that riot on the, I think it was the 6th of January, 2021, this year? Was that speech inciting to violence, or was it, and is it embargoed by the Constitution or not? And of course, the judgment of the Senate was that he was entitled to. But I mean, obviously, that the vote in the Senate was purely political, purely on party lines, so one can't really judge that. There were 7 in the end, 7 Republicans who voted with the Democrats. But that wasn't enough because they needed a 2/3 majority for that.